57, 59, 50, where is 57? 60, 61, 62, 4 BBA LLB, 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 13, 14, 15, 16, 17, 18, 19, 20, 21, 23, 25, 26, 31, 33, 21, 23. OC members or volunteers in this event, please make sure you come and get your attendance checked towards the end of the event. OC members or volunteers in this event, please make sure you come and get your attendance checked towards the end of the event. Reiterating the rules one last time, please make sure you're not using your phones, laptops, or any other technological devices. If found to be using, they will be confiscated. Secondly, please make sure you're not making any loud noises or gestures while the courtroom is in session. Please maintain the decorum, sanctity, and the proper procedure which has to be followed in any courtroom while during session. Thank you. They will be confiscated. Secondly, please make sure you're not making any loud noises or gestures while the courtroom is in session. Please maintain the decorum, sanctity, and the proper procedure which has to be followed in any courtroom while during session. Thank you. As soon as the judges will arrive, we all will give you a cue. Please stand up and make sure you're not making any noise while removing the flaps of your desk, and don't bang your desks. Everyone, please stand up. A very warm morning to everyone present. Our academic coordinator, Father Justin P. Verghese, our head of department, Dr. Anta Sebastian, our distinguished bench, Honorable Justice Osham Kumar Roy, Professor Dr. Jyotsna Yagnik, and Professor Dr. Shubir Kumar Roy. Respected faculty members, participants, and my fellow Christites. We are gathered here today for the grand finale of the 6th Themis Moot Court competition, and it is our honor to have this round presided over by such a distinguished bench. We are truly privileged by your presence. It is now my distinct honor to call upon Father Justin P. Verghese to felicitate our esteemed judges who grace this occasion with their presence. We are privileged to be guided by luminaries who contribute to the legal profession, judiciary, and academia, and continue to inspire generations of law students and practitioners alike. Father, I request you. We are honored to welcome Honorable Justice Osham Kumar Roy, former judge of Calcutta High Court and former Lokayukta of West Bengal. With a distinguished career in criminal law and public service, his lordship's contributions to the justice delivery and institutional integrity are truly commendable. We express our deepest gratitude for your gracious presence here today. We are privileged to have with us today Professor Dr. Jyotsna Yagnik, former Principal Judge of the City Civil and Sessions Court, Ahmedabad, and former Pro Vice Chancellor of the Adamas University. She is widely respected for delivering the landmark judgments such as the Narodia Patia judgment, bomb blasting Gujarat judgment, and the Puta case of larger conspiracy, and for her unwavering commitment to justice and human dignity. We are deeply honored by your presence and guidance. We are delighted to welcome Professor Dr. Shubir Kumar Roy, Professor, Department of Law, Bakura University, and former officiating registrar of Bakura University, a distinguished academician and an eminent contributor to legal education and scholarship. His dedication to nurturing future legal professionals and advancing legal research is truly inspiring. We sincerely thank you, sir, for being here with us today. I now request our distinguished bench to please take over the courtroom. Before we proceed to the final round, kindly pay attention to the rules for the grand finale. The two qualifying teams shall each argue for the site allotted. Both the teams must maintain the decorum of the court. Each team is allotted a total of 40 minutes, inclusive of the rebuttal and sur-rebuttal. Each speaker shall argue for a minimum of 16 minutes and a maximum of 20 minutes, subject to the discretion of this honorable bench. The division of the time between the speakers, as well as the allocation of rebuttal and sur-rebuttal, must be clearly indicated to the court prior to the commencement of their arguments. The teams are also expected to confine their arguments and issues framed in the Moot proposition and must rely only on the authorities cited in their memorials unless permitted by this honorable bench. Speakers shall address the bench with utmost respect and shall refrain from interrupting the opposing counsel. The decision of this honorable bench shall be final and binding. If the speaker 1 exceeds the allotted time, the excess time shall be deducted from the time allotted to speaker 2. In the event that speaker 2 exceeds their allotted time, the additional time shall be deducted from the rebuttal period. If the speaker 1 does not exceed the prescribed time limit and has complied with the minimum time requirement as stipulated in the rules, any requirements shall be transferred to speaker 2. Any further unutilized time may be subsequently be allocated to the rebuttal, subject to the overall time limit. And with that, with the permission of this honorable bench, we shall now commence with the final round. The courtroom is now in session. Thank you.
This is Council TC04, representing the petitioners, the Union of Indravarta in the present matter. Over the course of next 20 minutes, my lords, I shall be making submissions pertaining to the first and the second issue, followed by my co-counsel, who shall be making submissions with respect to the third and the fourth issue over a course of 17 minutes. We respectfully reserve 3 minutes for rebuttals. Much obliged, my lordships. Your lordships, on 26th of November 1949, when we gave ourselves this constitution, we promised ourselves a nation as a union of states with a quasi-federal governance structure. This present dispute goes to the very foundation of this constitutional scheme. It is in this moments of institutional friction between constitutional entities that a federal compact of a constitution is tested. The present dispute arises precisely from such an overbreach by the state of Kalinga. And thus, the Union has invoked the Honorable Court's exclusive ordinary jurisdiction under 131. This invocation is not merely for adjudication of a dispute, but it is for the vindication of the Union's constitutional authority, for the protection of freedom of speech and expression of the citizens of this nation, and to arrest an impermissible breach by the state of Kalinga in the Union's constitutional domain. In light of this, my lords, I have two broad submissions to make with respect to the first issue, which contains the maintainability of the present petition before the court. First, that the dispute pertains to a legal question arising between the Union and the state government, and therefore this suit under Article 131 is maintainable. Second, that the present dispute does not fall within the jurisdiction of Section 25 of the Digital Indravarta Telecommunications Act, or the DITA, and therefore the TDSAT cannot exercise its jurisdiction over this dispute. My lords, the question that this court is posed today has arisen before it multiple times when there is a conflict of jurisdiction. This court is called upon to decide which of the two adjudicating mechanisms should adjudicate upon the present dispute. But this court's jurisprudence in this line has remained consistent. It has always looked to the substantial question or the core of the dispute in order to identify which mechanism's jurisdiction would be most suitable for the adjudication of the particular dispute. In this case, we have invoked this honorable court's jurisdiction, while the respondents might submit before the court that it is TDSAT under Section 25 that has the jurisdiction. However, my lords, I would request over the course of my submission for the first issue, the court to identify the question that is present in the dispute. Article 131, there are two essentials for this court to exercise its jurisdiction. First, that the parties to the dispute must be the Union and the state on the other side, or between two or more states. And second, that it must involve a legal question pertaining to the relational or the federal relationship between the Union and the state. We submit that both these essentials are obliged and accepted in the present case, and the fact that the DSAT does not have jurisdiction makes this suit maintainable. My lords, I would like to rely on this court's 7-bench decision in the state of Rajasthan versus Union of India. My lords, in this case, yes, my lord. The memo? Yes, my lord. That is our memorial. If I may, please borrow 5 seconds from the court. My lords, it's on footnote number 17 in the argument advance section of the memorial. Footnote 17, my lords. 17, 1-7. Yes, ma'am, the footnote. Arguing maintainability. Yes, my lord. Yes, my lord. Yes, my lord. this blue one, my lord. Yes. Footnote number 17 of the argument. My lords, there's footnotes for the authorities. There's no page number in the memorial. We apologize for this. Footnote 17, my lord. I'm extremely sorry. My lords, I will lay down the facts of the case. Right. Correct, my lord. Correct, my lord. My lords, if I may continue. My lords, in this case, the Union Home Minister had sent a letter, a directive to 9 Congress rule states asking them to advise their governor to declare dissolution of the state assembly. My lords, these states approached this honorable court under Article 131. This union objected to the maintainability, stating that the state government in the favor of maintainability. Right. Right, my lord. Right, my lord. My lord, my submission to this effect is that it will not. And precisely why? Because this dispute involves a legal question pertaining to the federal relationship. And whenever federal relationship is concerned, this court's original jurisdiction will oust any other court's jurisdiction, because the Constitution itself says that the Supreme Court, to the exclusion of any other court, will exercise its jurisdiction. Right, my lord? My lord, precisely, if I will submit how this involves a legal question of the federal dispute. My lords, first, we would state that the term legal right has been defined by this court to mean any question involving power, liability, and any actions challenging between the union and the state which pertains to the distribution of power between them. My lord, here in this case, what has happened is we sent a directive to the state government and asked them to deactivate the jammers that they have employed, which was interrupting with the actions of a strategic national asset. Yes, my lord. Submitting. Yes, my lord. Yes, my lord. Right, my lord. And precisely why I'm submitting. My lord, because in their preliminary objections, they have challenged the maintainability of the suit, which made the court frame the issues in such a manner. And the first issue is this. And my limited submission is that why we have approached this court under 131 at the first place. And that is what I'm submitting, that this involves a legal question with pertaining to the federal relationship between the state and the union. And if I come to the facts of the case, my lords, this is where, when we ask them to... Absolutely, my lord. Absolutely, my lord. I agree with you. And this is precisely my submission, my lord, that we need to see that even if there's a dispute with regard to the existence of a legal right, my lords, if I may continue. Well, the existence of a legal dispute is also covered under 131. So when we directed them to deactivate the jammers, they invoked the Kalinga Public Safety Act. They said that we are in a state of public emergency, and that is why we will interfere with a strategic national asset. Therefore, Your Honor, my lords, you must see that there is a conflict between the executive exercise of the union of its powers, because telecom happens to be under the union list, entry 31. We have the exclusive right of legislating over that subject matter. My lords, they have invoked public order and police power, which is under the state list. So they are contending that their executive actions is constitutionally valid. So, my lords, my entire submission is this, that there is a clash of executive decisions of the union and the state. And this is no more a telecom dispute. It has arisen to the threshold of being a federal dispute between the union and the state. And only this court, the highest court, the ultimate arbitrator, and the guardian of the constitution has the right to adjudicate on such matters, such complex constitutional matters, and not a statutory tribunal that was constituted with the legislative intent to only adjudicate telecom-related matters. Correct, my lords. There are three essentials, and this dispute will not fall within any of the three essentials of Section 25. My lady, Section 25 states that the dispute must be a licensor or a licensee, or between two service providers, or between consumers and the service providers. This does not fall in any of the three clauses mentioned under Section 25. My lord has raised a concern with regard to the ouster clause, whether the ouster clause contained under 25(2) would override the jurisdiction of this court. My lord, if I sense a question. My lord, to this effect, my submission is that in state of Karnataka versus Union of India, and I particularly refer to the concurring separate opinion of Justice Bhagwati, wherein he held that this court's jurisdiction under 131 is an exclusive jurisdiction. It was, my lord, correct, my lord. And this is precisely what I'm submitting. That here also you need to see that the original jurisdiction of this court is much above the original jurisdiction of a civil court. Civil courts, my lord, would appreciate, derive their power from Section 15 of the Code of Civil Procedure, which states that the court of the lowest grade must be competent to try a particular matter. A court of lowest grade cannot be compared with the highest court of the land, and therefore a statutory provision cannot override the exclusive jurisdiction granted to this court under the constitution of the country. And this is my precise submission with respect to the first issue, that because there's a legal question involving complex constitutional matters and federal relationship, and that the telecom dispute settlement tribunal does not have exclusive jurisdiction of here, this court must consider this suit to be maintainable. Yes, my lord. Right, my lord. My lord, I would answer your question in two prongs. First, factually. In this case, my lord, we... No, my lord. No, my lord. My lord, my first question pertains exactly to what my lords has clarified, that Astronet has not been made a party, and here, because my lord, we have held that this is a clash, as I have submitted, of the executive decisions. We have exercised our exclusive right under Article 73 of the Constitution, giving executive directions in relations to the telecom sector. We have enacted a union law, the DITA, and we have asked the state government to comply with the DITA. My lords, if you see, the constitutional provisions also gives us the power to make such... Yes, my lord. It's in Union List, entry 31. Yes, my lord. And 256 states that whenever a matter is there in a Union List, we will have the power to direct to the state government to act in a particular manner. And they are constitutionally bound to act in that particular manner, which they have not. Therefore, they have clearly violated a constitutional provision, the separation of power and the federal relationship that we have with them. And that is why this dispute is maintainable before the court. My lords, with this, if the bench has no further question, I come to the end of my submission with respect to the first issue. If I may seek permission to move to the second issue. My lords and my lady, the second issue pertains to a very pertinent question. The pertinent question, my lords. Sure, my lords. Yes, my lord. I'll be careful about the time. One of the second issue pertains when the state of Kalinga has arbitrarily invoked its public emergency powers, went on raiding private homes of individuals, and confiscated 5,000 terminals of the Astronet. My lords, you need to understand the context in which the state of Kalinga operates. The state of Kalinga, for decades, there are also 15,000 villages in the state of Kalinga. And speech and expression. It can be, my lord, but the restriction has to pass the tests of proportionality and reasonability. My lord, the test of proportionality is given under in this court's three-judge bench decision in Anuradha versus Union of India. It's a 2019 decision pertaining to internet shutdowns. The court said that the restriction must be at most necessary. The restriction must consider if there are alternatives available or not, and the restriction must be the least intrusive method. My lords, this point needs to be noted and impacted upon that it must be the least intrusive method. Here, my lord. Yes, my lord. Right, my lord. Lord, I would beg the court to not go into that direction. But my lord, I will be short, and I'll directly refer to the facts as my lord has requested. My lord, when the 20 personals, which is a very unfortunate incident, when the 20 personals of the elite police forces were murdered by this VLF insurgents, the state government approached to us saying, turn on the geo-fenced kill switch. My lord, geo-fenced kill switch, if you would have turned on that, it would have rendered an entire area, probably half or more of the state of Kalinga, totally blacked out of communication. We would have lost communication with our own forces, and that would have exaggerated the situation and would have aggravated any danger this insurgents posed to us. Therefore, my lord, we requested them, we rejected their request, and we said, wait for 48 hours. 48 hours is the time the Astronet takes to reconfigure its system. Give us 48 hours. My lords, and we also said them that CRPF, the National Force, cannot be left incommunicado from the union government. They went on to arbitrarily invoke the state of their public emergency powers, went on raiding individuals. They did not even create a reasonable distinctions, my lord. They went on raiding private institutions, journalists, school institutions, and their actions affected medical hospitals and operations of airport, causing immense economic, financial, and loss to life in this present case. My lord, with this, I submit that the state's action is clearly disproportionate with respect to the threat that was posed to it. My lord, they also decided to raid the homes and confiscate on 5th of January 2026. And the incident of burning and live streaming had happened on 15th December 2025. So there was a gap of approximately 20 days. Therefore, there was no emergent or necessary danger they thought to tap by confiscating these terminals. My lords, we have been cooperating with them, financing their struggle against these insurgents' movements. We have been giving them technology. We have been training our own forces to act in this direction. And thus we requested them that we will take actions, but give us some time. My lord, cooperative federalism, I agree. And that is why we were with the intention to cooperate with the State Digital Intelligence Unit. We would have found out where exactly these terminals were operating from. They have found out that it was operating from a forest area in Malkangiri district in state of Kalinga. My lords, we would have identified because we would have got information from Astro terminals. By the way, my lords, statutorily only we have the right to intercept from Astro terminals the exact locations of these identities and the insurgents. We requested them that give us their time, we will tap them, arrest them, and exercise due procedure upon them. They did not abide by this. In turn, what they chose to do was infringe upon the rights of the citizens of this country, violating their right under Article 19(1)(a), and also, as my lords pointed, their right to occupation, because journalists need internet for any operation they want to do. With this, my lord, I come to the end of my submission, and I would also state that their action is clearly violative of the Constitution. Thank you, my lords. It was an honor argument.
record concerns the sealing of the Gateway Earth Station at Chandragiri Hill on the pretext of public health. And the fourth concerns the deployment of spectrum jammers by the state of Kalinga in order to deal with the VLF insurgency. My lords, our founding fathers sought to create a federal balance. This intent of the founding... Who was your founding father? Your lordships, the Constituent Assembly in its entirety were our founding fathers. Your lordships, this intent of the founding generation is reflected in the three lists of the 7th schedule. Your lordships, the state of Kalinga breaches this federal balance today. In light of this, I have two broad submissions to make before this court. First, the Digital Indravarta Telecommunications Act was within the legislative competence of Parliament. And second, there were no serious public health concerns with respect to the Gateway Earth Station at Chandragiri Hills. Beginning with the first submission, your lordships, on 2nd January 2025, my lords would refer to paragraph 22 of the Moot proposition in this regard. Your lordships, we have conducted a term report which detects electromagnetic radiations that have emanated from the Chandragiri Hill Station. Our reports have concluded that the electromagnetic radiations were only 1/10 of the prescribed limit. Okay. Therefore, there were no serious public health concerns with respect to this Gateway Earth Station, and we have done our due diligence. Your lordships, despite this, the Kalinga Municipal Corporation sealed the Gateway Earth Station at Chandragiri Hills. Now, despite that? Yes, your lordships. Please repeat. Your lordships, despite this term cell report, the Kalinga Municipal Corporation sealed the Gateway Earth Station at Chandragiri Hills, citing that there were public health concerns. Now, your lordships, this action is in teeth of data. What were their means to know? My ladyship, there was a local NGO report by Green Kalinga which cited that there were some public health concerns, that there was some cognitive dissonance, etc., that the villagers faced. But my lords, one important facet to note over here is that this local NGO had received a grant from the Chief Minister's Relief Fund just 1 week prior to this report. Your lordships, therefore, this entire report is marred by colorable intentions. So have you gone through veracity of that report? Your lordships, as I made my submission, radiation, and the High Court have been confronted. For instance, mobile towers was erected. Petitioners challenged it on the ground of electromagnetic radiation. This court has relied always on term reports because those are reliable reports. And in this instance, the term report itself said. 1 minute. The report that was you are providing, that is the import of this. Yes, ma'am. And that NGO report is provided by who? On their own, they are stating that it is an environmental expert. Our question is, yes, trying to understand. Yes. Once you are trying to establish report of expert. Yes. NGO is given as a. Yes, ma'am. Why you are not considering that a report of an expert? No, there. My lords, if I may please draw your attention to paragraph 22 of the Moot proposition, and I will allay your concerns. My lords, if you may, this is the paragraph 22 states. On 2nd January, the Kalinga Municipal Corporation pasted a show cause notice on the Astronet Gateway Station. The notice cited a report by a local NGO named Green Kalinga. And my lords, appreciate the last time. My lords, I will submit that this action of the Kalinga Municipal Corporation is in direct teeth of Section 20 of the Digital Indravarta Telecommunications. In this regard, my lords, if I may refer your lordships to the second last page of the Moot proposition where Section 20 is contained. Your lordships, if I may read for the benefit of this court. Your lordships, it starts with a non-obstanding clause. It states, notwithstanding anything contained in any state act, municipal act, Panchayat Act, or any bylaw of any local authority, and notwithstanding any judgment, etc., no state government or local authority shall have the power to deny, seal, obstruct, or revoke permission for the establishment, maintenance, or working of critical national infrastructure. Your lordships, the Gateway Earth Station at Kalinga has been designated as a critical national infrastructure, and their actions, which are municipal actions, are in direct teeth with data. Now, your lordships, Learned Counsel for Respondent may submit that insofar as this non-obstanding the legislative competence of a particular legislation is impugned, this court looks at the true character of the act and not at incidental transgressions. Therefore, even if there are incidental transgressions into the state domain, those transgressions are ignored when we look at the true character of the act. Now, your installation of satellites, the licensing of spectrum, and so on and so forth. Now, these incidental transgressions into public health, into land, are merely incidental. And your Lordship's judgment in A.S. Krishna versus State of Madras itself states that your Lordship should not disintegrate sections of an act and should look at the act as a whole in order to look at whether there is legislative competence to deal with this subject matter. Your Lordships, when we look at data as a whole, it is exclusively within the union list, which is entry 31, which deals with posts and telegraphs.
So you are admitting that it is incidentally encroaching into the field of health.
We concede.
You are admitting.
We concede, and it is a line of decisions of this court, my lord, that incidental transgressions must be ignored when you look at the truth.
Should it be non-obstacle clause or provision? What you are referring to? Should it be non-obstacle or provision? What?
My lords, we are submitting that this is a non-obstacle clause, and we are submitting that this cannot impede any other act or municipal act, etc., etc. And if it impedes, it is only an incidental transgression. My lords, my second submission is that if this court is not able to reconcile public health with posts and telegraphs, this court has always applied the doctrine of harmonious construction. Well, the Lordships, the doctrine of harmonious construction says that when we are interpreting this conflict between two entries, your Lordship should not render any of those entries completely nugatory or completely unworkable. You should give some effect to both of those entries. Your Lordships, in this case, the doctrine of harmonious construction would apply in such a situation where, insofar as telegraph is concerned, the union has complete power, and the union has power to declare something as critical national infrastructure. Now, the Kalinga Municipal Act is applicable to all aspects of health. Wherever there is a public health emergency, anything to do with public health, they have the power to do so, just not with the infrastructure which is declared as critical national infrastructure. Because that would render section 20 clause 2 obtuse or negative. And that is our precise submission without section 20. Your Lordships, my third submission in this regard is that this particular act, DETA, has been enacted in pursuance of an international treaty. The international treaty in this regard is the Geneva Protocol on Universal Satellite Access. Now, my lords would appreciate that there is Article 250 to an international treaty, international convention, and 253 also starts with a non-obstante clause. Then Parliament can encroach even into state subjects. Your Lordships, this court has consistently held in S. Jagannath versus Union of India and other cases that Parliament can exclusively deal even with state subjects when you are giving effect to an international treaty. If you read the statement of objects and purpose of DETA, my Lordships, I would just read for your benefit of this court. Indravarta is a signatory to the Geneva Protocol on Universal Satellite Access, and the said protocol banned land connectivity. To give effect to this international treaty under Article 253, they have enacted. Your Lordships, holding today that DETA would be inapplicable or DETA would be void, would counter our international obligations and put this entire country in jeopardy. Your Lordships, therefore, we submit, and our humble submissions with respect to issue 3 are that DETA in its whole is constitutional. If my Lordships have no further question, I may now move to the fourth issue. Your Lordships, the fourth issue concerns the use of spectrum jammers by the state of Kalinga in order to deal with the VLF insurgency. Spectrum, three devastating effects resulted out of this incident. Your Lordships, the entire women of this country.
What is the base to believe?
My leadership would refer to the proposition. My leadership, it's on paragraph 34 of the Moot proposition. It states, the jamming created latency jitter. On 10th January 2026, the National Stock Exchange at Meridia suffered a flash crash, wiping out 1,500 points as high-frequency trading algorithms failed due to packet loss. Therefore, your Lordships, when these spectrum jammers were employed, these somehow led to the entering them into the national network, and therefore the entire national network was disrupted. This also caused disruptions in the flight radar, at AIMS Hospital being rendered a failure because of this action. Your Lordships, a single action of the state of Kalinga has led to 3 devastating effects for this country. Your Lordships, the state of Kalinga did not have a statutory anchor for their actions. It was a pure and simple executive action. Your Lordships, entry 31 of the Union list states that with respect to posts and telegraphs, and the definition of telegraph also includes spectrum, is in the exclusive domain of the Union. And there is a very important reason for us to do so. May I engage this court with a hypothetical? Your Lordships are using cell phones, mobile phones. And I'm sure your Lordship must be using 4G, 5G, etc. I am using mobile phones, and the entire courtroom is using mobile phones. The 95 crore people of this country are using mobile phones. Now, my Lordships would appreciate that all of these mobile phones are merely based on 4 frequency bands, spectrum bands. Therefore, jamming even a single band leads to the complete blackout of 20 crore mobile phones. That is exactly what has happened in the state of Kerala. A single spectrum band, which is from 27 gigahertz to 29 gigahertz, has been disrupted. And that has caused a complete blackout in the state of Kalinga. Your Lordships, the state of Kalinga is such a state where terrestrial network is negligible. 15,000 villages, there was no terrestrial or mobile network. The astronet brought light, digital light, to Kalinga. And the actions of the state of Kalinga have rendered the people of Kalinga back into darkness. Your Lordships, on this note, may I submit that with respect to public order and these conditions, the state of Kalinga has complete authority. However, your Lordships have held, in the case of Anuradha Basin versus Union of India, that when acting in pursuance of public order, the state must demonstrate necessity and proportionality. They must show that their actions were the least intrusive measure that they could have employed. Your Lordships, the least intrusive measure in this instance could have been, and I would have to explain your Lordships the technology of how this works. Your Lordship, there are astronet terminals, basically handsets. These handsets put out beams into the lower orbit satellites. And from these satellites, the radiations come back to one gateway Earth station. There is a single gateway Earth station. With respect to VNF insurgents, your Lordships, these beams do not come back to the gateway Earth station. They go to the Republic of Belarus.
One last question.
Yes.
From my end. Yes. Why your convincement would not be considered a political question more than a legal question?
My Lords, it is precisely because of Article 256 of the Constitution. Your Lordships, may I refer to Section 4 of the Digital Indravarta Telecommunications Act, which is the data. Your Lordships, it is in the clarifications that have been provided by this court, or by the bench. It states, Section 4 states, and this is a parliamentary law, my Lord. It states, any spectrum designated by, yes, my Lord, just answering this question. Any spectrum designated by the central government under this section may be classified as a strategic national asset, and no state government shall have the competence to regulate, audit, or restrict the transmission of signals on such assigned frequencies. Therefore, your Lordships, their actions in jamming the spectrum were in direct contravention of Section 4.2 of data, and therefore they had no legal basis to make this claim. Whereas us, because of Section 4.2 of data, have a legal basis to state that the state of Kalinga interfered with spectrum, which was a strategic national asset. That is, my Lord is satisfied with this answer. I come to the end of my submissions with regards to issue 4, and I thank the court for its time. It was a pleasure arguing. Sure. Your Honor, the counsel appears before this honorable court on behalf of the defendant, State of Kerala, the matter of Union of Indravata of the State of Kerala. I, the counsel, shall be addressing the facts of this case, issue 1 and issue 2, and shall speak for 18 minutes. My co-counsel shall be addressing the third and the fourth issue, along with the prayer sermon, and shall be taking another 18 minutes, and we shall be reserving the rest of the time for self-defense. As my learned friends have already established the facts of this case, the counsel would simply like to clarify certain facts that they are misled to this point. Firstly, Your Honor, the plaintiff claimed that the union was ready to provide remedies within 48 hours. That statement is factually incorrect, as the union downright rejected our request to provide a geofence kill switch, despite the VLF's attack on 20 Greyhound personnel and the live streaming of the same. Second, the plaintiff claims that they were observing and working towards the de-escalating of the insurgency and have advised their personnel to act accordingly. This statement has no ground, Your Honor, and is completely absent of the factual basis. My learned friends have also cited that the state acted on the NGO's report and has misled this honorable court by the omission of Annexure 2. If the counsel has provided a copy of the Moot law with the flags attached in order for the convenience of this court. Flag 2, Your Honor. Flag 2, the blue color. The connection. Yes, Your Honor. If Your Honors would refer to the next page of that article. Next page. Yes, sir. The very first line. It states that the State Health Commission conducted an independent inquiry and has come to the conclusion that there were high radiation emissions resulting in adverse effects on the residents and the surrounding ecosystem. If the lordships may kindly refer to the last para of the arguments advanced on the plaintiff's memo. Yes. They claim they have misled this court by creating a discrepancy in their written submission and in their oral pleadings. In their oral pleadings, they have claimed that there is an economical damage extending to 500 crores. But in the written pleadings that they have claimed, it is 2.4 trillion rupees. With that, the counsel would like to proceed with the first issue. The counsel acknowledged that there could be a computational error, but there's a discrepancy in the pleadings. Your Lordship, the first issue involves on the fact whether the present suit is maintainable under Article 1. My learned friends have relied heavily on the DI, but have conveniently ignored the jurisdiction that the Act provides. Your Lordships, before this honorable court proceeds to examine the merits of the present dispute, the defendant respectfully submits that the threshold jurisdiction bar annexes, which goes to the very root of the matter. Your Honor, whether the present suit is maintainable under Article 131 and all. The defendant respectfully submits that the present suit is not maintainable on the following grounds. First, that the dispute arises out of telecommunication regulation governed by special statutes, namely digital.
You are saying the special statute will prevail over the constitution and functions.
Your Lordships, as the dispute arises from telecommunication dispute, hence
Anything 7 schedule includes this corporate list or it will be Indian list or state list.
if your Lordships may kindly refer to flag 5 of the defendant's compendium. Defendant's compendium. It is right under the 5. Flag 5.
By the time my brothers were
Indeed, Your Lordship. This honorable court in Union of India versus Tata Teleservices stated that dispute between the parties concerned, which would involve significant technical aspects,
have to be determined by a specialized tribunal constituted for that purpose. And even a Latin maxim, generally a special the para has been highlighted. Shall the council the council was referring to the case law as a response to your
No, this case law, you have seen that in the constitution that is Article 264, that is the water related dispute. That the that is not in case law.
The council acknowledges the argument being made
That has been clarified in the constitution itself.
The council acknowledges that, but the council would like to clarify.
I said, the constitution, if you see that if there is a river dispute, that is always referred to the Godavari river dispute. Those are the refer to the tribunal. But this is not such type of dispute. So that constitution lie and
Indeed, your lordship, the council acknowledges that the water tribunal has been specifically provided in the constitution, but would simply like to clarify that the union itself has enacted a special statute in order to establish jurisdiction for any sort of disputes under telecom communications, and hence under
that relates to the dispute between the licensor and the service provider. That is specifically.
the council acknowledges that the jurisdiction was limited to, but they would like to clarify that the present dispute is about the spectrum usage, not about the constitutional right or the legal right of the claim. And even in the maxim, generally a special is non-derivate, meaning things general do not derivate from things special. Your Honor, hence, where there exists a dispute over a general law and specific law, the latter takes precedence. If your lordships are satisfied, the council seeks permission to proceed to next slide. Much more.
Jurisdiction is a mixture of fact and law. Do you agree?
Yes, Your Honor.
And facts are also to be seen.
Indeed, Your Lordship. And the facts are in favor of the defendant. As a present matter, the factual matrix clearly states that the present matter is a telecom dispute. But the plaintiff dragging this honorable court, claiming that it is a constitutional violation. And the council would be clarifying on how these factual matrices are a telecom dispute and not a constitutional right.
Doing jamming is also telecom dispute. Violation of right of everyone.
Your Ladyship,
Constitutional rights of the people at the
Your Ladyship, considering the gravity of the situation the insurgents have created, the state was left renderless but to instill jammers in order to protect its own sovereignty and establish public order. The state had sought relief from the union, Text Act, but the union downright rejected our request and the Text Act was unavailable. And hence we were left renderless but to take necessary action. Much obliged. The council shall be proceeding with the The controversy before this honorable court pertains to telecom infrastructure, spectrum allocation, licensing condition, and alleged operational interference. These are matters that arise directly under the DIA and therefore fall within a statute, not constitutional. If your honor may kindly refer to page 34, annexure 7 of the Moot Constitution, flag 7. It underscores that the depreciation and adverse environmental implications and the issue concerning environmental implications of the gateway infrastructure and the alleged misuse of spectrum by insurgent groups are inherently technical in nature, and such matters fall squarely within the specialized domain of business, which is equipped to adjudicate complex questions involving telecommunication regulation and spectrum management. Accordingly, these issues ought not to be determined by this honorable court, but by a specialized court. Your Honor, the unlawful transmission by the insurgent is also addressed through clause 19 of the WPC assignment text, which clearly states that any unauthorized transmission shall attract section 44 of the DI. Your Honor, this honorable court has consistently emphasized that where Parliament established a specialized adjudicatory mechanism, such mechanism must be given due effect. This honorable court held that despite disputes arising out of telecom licensing and regulatory obligations must be resolved within the telecom regulatory framework itself. Your Lordships, the plaintiff seeks to invoke Article 131 solely on the basis that the dispute is between the union and a state. However, Your Honor, it is a settled law that the nature of the dispute, not the identity of the parties, determines jurisdiction. This honorable court held that Article 131 cannot be invoked merely because the parties are governmental or personal. The dispute must involve legal rights, not statutory or administrative rights. Similarly, it has been clarified that
What's the difference between legal right and statutory? Difference between the legal right and statutory.
Legal right, as according to Article 131, legal right is something that the plaintiff or the union in the present case has been enshrined through with the constitution. Whereas an administrative issue or a statutory issue pertains to any sort of discrepancy in the statute itself or the actions of the other parties.
So you are saying that whatever has been provided by the constitution, that is our legal right, and what the statute provides, that is the statute. Is it your
The council was referring to a statutory issue or an administrative issue. Administrative issue shall not drag
Not saying now legal right and statutory right. Okay, carry on.
No, whether you 131 saying this, that legal right, there is a legal right.
Yes, Your Lordship. The Article 131 refers to specific terms such as legal right. Violation of legal right shall attract Article 1. If Your Lordships are satisfied with the council, much on.
That is the correct proposition, that 131 attracts the legal right.
Indeed.
But I am asking you that it is the reference statutory right and legal right. But it is not a legal right, it is a statutory. Therefore, it is not attracted. So I want to know what is the distinction between the statutory right and legal right.
The council is
All right, you carry on.
The council will try to simply define their submission. They meant administrative and statutory issues and not rights. Apologies to the. If Your Lordships will kindly refer to para 25, line 3, flag 25 of the Moot proposition, the council can read out the specified much. It reads as the tribunal registry refused to list the matter for 7 days, citing summer vacation and lack of work. This fact is relevant to as the state did approach the TSAT, however the tribunal was not functional due to lack of work. Your Honor, the union cannot establish an exclusive forum, allow it to remain non-functional, and then seek to bypass it by invoking Article 1. And such an approach would defeat the very purpose of the statutory framework. To permit such bypassing would render the statutory scheme redundant. With that, if Your Lordships are satisfied with the first issue, the council seeks permission to move the second issue.
And you cannot say whether we are satisfied or not. You may proceed to the next step. You cannot assure me that
We are not supposed to be doing this.
finally after you finish one day,
Indeed, Your Lordship.
you are satisfied that time is over.
The council would then be short with the second issue.
Not take your
Much of it. Your Honor, the second issue revolves around the fact whether there was a violation of Article 19(1)(8) and Article 6. Your Honor, the issue concerns the alleged violation of fundamental rights. However, the defendant respectfully submits that the present case is not one of denial of rights, but of lawful restriction in the face of an immediate and grave threat to public order and national security. It is respectfully submitted that there is no violation of Article 19(1)(8) or 40 for four principal reasons. First, the right to internet access is not absolute. Second, the measures were in response to a real and demonstrable threat. Third, the action satisfied the test of proportionality. And fourth, the classification adopted by the state is reasonable and constitutionally valid. Your Honor, the internet access has been read into Article 19(1)(8). This honorable court in Anuradha Vasan v. Union of India has unequivocally held that such a right is subject to reasonable restriction under Article 19(2), particularly in the interests of state sovereignty, security, and public order. In the present case, Your Honor, the factual matrix clearly demonstrates a serious breakdown of internal security. The insurgent group, the VLF, has evolved beyond a mere militant outfit into a parallel government authority collecting taxes, conducting quasi-judicial proceedings through Jan Adalas, and directly challenging the sovereignty of the state. Further, paragraph 17 and 18 of the Moot proposition, Your Honor, reveals that the insurgents were not only using encrypted satellite networks routed through foreign jurisdiction, but also coordinated a deadly ambush, resulting in the martyrdom of 20 elite Greyhound personnel. While live streaming the attack, Your Honor, this establishes not merely a law and order issue, but a clear and present threat to national security and public order. Your Honor, in such circumstances, the state was not acting in abstraction or apprehension, but in response to a demonstrable, immediate, and technologically sophisticated threat, which rendered conventional surveillance mechanism ineffective. Your Honor, therefore, the restriction imposed was squarely within the scope of Article 19 and were necessary to restore public order and safeguard the sovereignty of the state. Your Honor, the present case involves a provision misuse of Article 19 clause 2.
That is not subject to reasonable restriction.
Article the council is claiming that reasonable restrictions has been provided under Article 19 clause 2.
What reasonable restriction?
In the present matter, the state, due to the fact that the BLF has grown.
My question is, when this provision was so worse, the union government is supposed to maintain sovereignty, because sovereignty mainly lies with that. I'm not going into that detail. So if the situation was so worse, why they have not came before the court? Why before that, the matter which is not within your jurisdiction, you import that?
Indeed, Your Lordship, the council acknowledges that the state should have approached the union on it, which they did. They approached the union for a geofence privilege. Appreciate, and the court may appreciate that.
How you can invoke the matter which is not within your jurisdiction?
The state would like to clarify that they were left helpless.
This is not within your jurisdiction.
Indeed, Your Lordship. But when it comes to state
You
sovereignty,
cannot legislate on the subject.
indeed, Your Lordship, the council acknowledges that the telecommunication is an exclusive domain of the union. But
7 schedule does not permit.
indeed, Your Lordship,
How you can take exclusive action?
when it
The question of exclusion is far away. First of all, you can legislate law
indeed,
governing the
That's
subject.
not within that.
indeed, Your Lordship, the council would like to say that they are not claiming that the telecommunication is in the state's domain. They appreciate that it is completely under the union's domain. What the council is pleading that when it comes to state sovereignty and public order, list 2 entry 1 clearly states that public, when there is a
State doesn't mean only the state of Calico.
Province.
It's the union also is the state.
indeed, Your Lordship,
State
As
is
a whole,
the
it
whole
is a
country,
state.
not your province.
indeed, Your Lordship, the council
Province is not supposed to maintain that.
indeed, Your Lordship, the council would simply like an extension of a minute in order to satisfy the query and also summarize. The council would then summarize in order to establish in order to respond to Your Lordship's query, the council would like to submit that the issue was pertinent to state sovereignty and public order, coming directly under the domain of the state, and the state's action was in line with constitution. And as the council sends the question for the bench. Should the council listen?
Done.
Thank you so much.
Your Honor, the necessity requirement is also satisfied in these actions, as less restrictive measures failed despite the telecom platform. Astranet bypassed it, the union denied a kill switch and criticized us and the council will simply come to the closing statement of the
Thank you.
The council would now like to invite the co-council to address issue 3 and 4. It was a pleasure arguing.
At the outset, the center licensed a foreign-controlled satellite network over Kalinga's most volatile terrain. It designated the frequency as a strategic national asset. And your Ladyship, when that very network was captured by armed insurgents when 20 state officers were brutally martyred, the center failed to act. It now asks this court to hold that the state had no power to protect itself. Your Honor, this counsel seeks permission to start with issue 3. Much obliged. Your Honor, the issue deals with whether the state's actions of sealing the GES are a valid exercise of state powers, and the counsel herein presents 3 corollary risks. First, the sealing of the Chandrapuri Gateway Earth Station was a legitimate exercise of state powers. Second, federal supremacy, Your Honor, does not immunize infrastructure that has itself become a vector of harm. Third, that the factual record discloses a rational basis for the state's intention. Your Honor, I begin with the proposition that this court is authoritative and that the petitioner cannot dispute. Your Honor, if you could please refer to the fact 15 of the defendant's complaint. Much obliged. Your Honor, as this honorable court held in the case of S.R. Pune versus Union of India, the states are constitutional, are coordinate constitutional units. The union cannot extinguish the powers of the state merely by legislating broadly or affixing the label of critical national infrastructure to an asset it chooses to protect. Your Honor, entry 6 lists 2 of the 7th schedule of the Constitution, vests public health with the state. Your Honor, entry 18 vests land and public order is vested in entry 1 as my counsel stated. Your Lordships, these are not peripheral or residual powers. They are the state's most fundamental constitutional responsibility. If your Lordships will please refer to Annexure 2 of the Moot proposition. Your Honor, the KMC order responded to valid concerns. 1,500 residents of tribal hamlets filed a petition documenting cognitive disturbance, sleep disruption, and adverse ecological effects that coincide with the operationalization of the Chandrapuri Gateway Earth Station. Your Lordships, the State Health Commission followed the report and conducted a preliminary independent inquiry and found sufficient cause to proceed. Your Lordships, the dominant purpose of the KMC order was to protect the local inhabitation at Chandrapuri from these alleged hazards.
Before taking this drastic measure, have you suggested any alternatives to the pollution caused by electricity?
To answer your Lordship's question, your Lordships, in the case of your Lordships, in the case of the Welfare Foundation, it has been stated that the state has the right to preempt and protect itself from preempting ecological harm, and it was the first time that the precautionary principle was applied in the country of India. And the state's actions are funded by this local government. Much obliged. Your Lordship, my learned friend has rightly stated that incidental encroachment does not stand as an entire encroachment of the actions. Your Lordship, under the doctrine of fifth and substance, affirmed in Prafulla Kumar Mukherjee versus Bank of Commerce Limited, and further reiterated in the state of Bombay versus F.N. Valsara, if your Lordships could please refer to the fact 11 of the document. Your Lordships, the substance, if within the substance of the state's actions falls within the domain of authority instituting it, and it is valid, even if it incidentally touches another legislative space. Your Lordship, the dominant purpose of the sealing order was to address the local public health and land use concerns on state territory, not to relicense or regulate satellite communications which is rightly vested with the union as they have stated. Your Lordship, its effect on entry 31 list 1 is purely incidental, and the incidental effect does not invalidate the dominant purpose of the actions here in your Lordship that were taken by the state of Kalika. My Lords, the petitioner is further argued that section 20 clause 2 of the DITA, the Digital Interval.
How is your matter fit and substance established?
Your Lordships, the fifth and substance determines.
You have not enacted any legislation, you have taken action, executed action. The union government has enacted the legislation and their contention is the application of the law. How is your matter fit and substance?
In the all state action over critical national infrastructure. Your Ladyship, the respondent submits that this argument, if accepted, produces results which are manifestly absurd. Please consider this, Your Honor. Absolute immunity would mean that a gateway Earth station could emit genuinely dangerous radiation. It could contaminate groundwater, and the state would be powerless to act because the data's non-obstanding clause would prohibit any local intervention. Your Lordship, the doctrine
Which can continue to long run.
a hypothetical scenario, Your Lordship. Your Lordship, in the case of Venkataramanan Devulu versus State of Mysore as is given under flag 12 of the compendium, Your Lordship, the doctrine of harmonious construction as affirmed in this case requires that entry 31 be read with entry 6 together so that the effect will be given to both of these statutes. Your Honor, entry 31 vests in the Union rightly the technical, licensing and systemic aspects of the telecommunication network. However, Your Honor, entry 6 empowers the state to respond to the on-ground public health concerns due to the physical installations within its territory. These are complementary domains, Your Honor, not contradictory. If my lords may please refer to paragraph 15 of the Moot resolution. My lords, the lease agreement that has been contained in paragraph 15 was signed between AstraZeneca and AIDC. Your Honor, it also contains an express proviso which conditions AstraZeneca's occupation of Chandragiri Hills on compliance with the state pollution control law. AstraZeneca has voluntarily accepted this condition. The union, Your Honor, as AstraZeneca's licensor, was aware of the condition and by extension have accepted it. Your Honor, by doing so, both union and the AstraZeneca acknowledge that state land law and state environmental standards would govern the physical presence of AstraZeneca on Kalinga's land. Your Honor, the state's cancellation of that lease upon breach of the condition is a straightforward exercise of entry. Your Honor, the licensor and licensee agreement that exists between the center and the state is completely independent of the rental agreement, the lease agreement between AstraZeneca and the state. Your Honor, what the state has done has simply is simply independent of the licensing agreement. AstraZeneca is free to function in the state of Kalinga provided they follow the conditions set in the agreement and by the SPC. Your Honor, on the second limb of the argument, the federal immunity does not suspend state sovereignty over citizens' welfare. My lords, the court has held in the case of Subhash Kumar versus State of Bihar that Article 21 includes the right to a pollution-free environment and that the tribal communities of Malkangiri are Kalinga citizens. Their constitutional right to a safe and healthy environment, Your Honor, is the state's responsibility. The responsibility does not simply evaporate because the source of potential concern happens to be a central license.
What's your contention about the audit report that has been submitted on behalf of the union?
Indeed, Your Lordship. Your Lordship, the audit report that has been submitted by the union has been conducted independently by the union. The concerns that the state of Kalinga is seeking to protect, the concerns of the tribal hamlets, is specifically.
That's going to technical.
Your Lordship, it has been conducted ex parte. The state of Kalinga has not been made party to it. There has been a breach of national justice in the condition of the case. Your Lordship, the audit report seeks to examine the gateway Earth station that has been stationed at Chandragiri, one of Kalinga's most volatile territories. Your Lordship, yet the union has chosen to ignore the special circumstances that surround the Chandragiri hills
But
and
when this NGOs make some submissions, you also supposed to have made a report from the health department. That time you also asked them to talk.
That's not consulted people.
You did not talk to the central government.
Your Lordship, the report that was furnished by the state is simply a response to the NGO report that was filed. The Lordship, the doctrine of intergovernmental immunity prevents states from discriminatingly targeting or destroying union functions. The state did not attempt to regulate astronaut satellite network or its technical operations. It applied the same environmental standards that any installation on Kalinga's land would face under lease proviso and health regulations. And, Your Lordship, as stated earlier by the Council, under the precautionary principle which is affirmed in Fellow Citizens Welfare Forum, which is compendium, which is fact 14 of the Dependence Compendium, Your Lordships, the burden of proving environmental safety lies with the party asserting it and not with the communities facing the risk. Your Lordships, my learned friend in his submissions earlier has stated that the public health concerns were manufactured and did not exist. However, Your Lordships, there has been a petition that was signed by 1,500 residents of tribal hamlets, which is enough to cause doubt in the minds of the state that there has been an ecological concern that has been rising out of the radiation levels of the Chandpur station. Your Lordships, consider also the position of these tribal communities. They had no voice in the WPC spectrum assignment process. They had no participation in the term cells audit report, which was conducted on astronauts on the state's own, the center's own certification. Your Lordships, the state of Kalinga is the only government that is constitutionally accountable to these communities. A reading of federal immunity that completely displaces the state's environmental jurisdiction would leave them with no government protected at all. Your Lord, Article 14A, when read up Article 21 of the Constitution, imposes on the state a duty to protect and improve the environment. And it creates a judicially enforceable environment obligation. Is there a question on the floor? Indeed, Your Lordships, there is a judicially enforceable environment obligation on the state government. And the state of Kalinga, in exercising its entry 6 power, was not defying the constitutionally, but instead enacting it. Your Lordships, on the third limb, the factual record supports precautionary prevention. Your Lordships, a statutory authority, the State Health Commission, conducted a preliminary inquiry and found sufficient cause to proceed. As stated earlier, there was a signed petition. There was disturbances in sleep patterns, cognitive disturbance, and adverse effects on cattle milk production. Perhaps the state was not acting on conjectures, it was acting on articulated document concerns from affected communities. Your Lordships, the plaintiffs have stated that there has been no independent state report. However, if Your Lordships would please refer to the plaintiff's memorandum, the last 4th page, Your Lordship, I'm unable to furnish the page number. The third argument, the last 5th line, they have stated there has been no independent state health communication report. However, that is manifestly false, Your Lordships, as has been stated in Annex 2 of the Moot proposition. Perhaps moving further, the ICNIRB guidelines that dictate radiation levels are minimum threshold standards. They do not preclude more cautious regulatory approaches for vulnerable populations. Your Lordship, the tribal community of Multi are precisely living in remote forest areas without access to medical care and without any institutional avenue to participate in central spectrum allowance, and are precisely the vulnerable population that the state of Kalinga is constitutionally responsible to protect. Your Lordship, the Council seeks to move on the issue. Much obliged. Your Lordship, spectral jamming was a valid exercise of power, and the state acted in exercise of its police power to confront an internal security crisis. That its conduct does not fall under the ambit of unauthorized use of spectrum or technical sabotage under the NICA. The application of the doctrine of necessity is valid and stands strong. Your Lordships, under para 6 and para 18 of the Moot proposition, as has been flagged, at the juncture of state intervention, the PLF had effectively declared a parallel government had established its own courts, its own tax collection regime, and ambushed and killed 20 special force police personnel, and even had gone to the extent of live streaming this grotesque execution using astronauts' high-speed satellite links. The data was routed to Frankfurt in Germany alone. In these facts, the state's objective is clearly rooted in NG1, is to disrupt the command and control network of a violent group on its own. Your leadership, a state cannot be a mute spectator when its basic law and order functions are under frontal assault. The union's exclusive privilege over telegraphs cannot create a constitutional refuge for insurgents. My Honor, I would like to summarize the arguments due to the paucity of time.
1 minute,
If Your Honor may allow me an extension.
earlier we asked for
Your Honor, under entry 1, the state was duty bound to disrupt that command structure, and it could not remain passive. The state cannot stay idle in the face of its own functions being violated. This is not technical sabotage, Your Honor. Section 44 targets malicious interference against union interests. Here the intent was opposite, to protect both state and union security, where existing mechanisms had failed. Finally, Your Honor, necessity is clearly established. The state sought a geofence solution, approached the death side. Much obliged, Your Honor. Pleasure arguing before the commission.
Tell me first. You follow?
Maximum.
How much time he will get for rebuttal? 3 minutes. 3 minutes. Oh.
I love this. I have 3 points of reference to the submissions made by the defendants. First, they stated that we have been factually misrepresenting the document, which my lord was kind of quantifying the computation, which is something which is not computational. There was a daily loss of 500 crore rupees, which over the period of time the channel was employed would amount to 2.4 trillion, which were being under submissions. Secondly, my lord, their entire argument against maintainability is that on the rely on the legal maximum jail, their specialist not there.
They have said why it is still, but you have not referred their report. That is why they are saying that you have. You have referred your report, but they have also uploaded the report that you have not seen.
Because the show was doing something wasted. We only mentioned the injury. And the State Health Commission does not measure the radiation level. It was very objective.
Whatever it may be, but you should have referred. Before the court of law, it should be fair. Fair enough. Because when you are that you say that you have, I have the expert report, they don't have. They relied on the report of the this thing. They are only NGOs claim, and on the basis of that they proceed. But that is not. Anyway, come to the next point. Come to the next point.
This legal maximum will be the applicable when there is a general statute and a special statute. Here, this court's jurisdiction under 151 between the union and the state is exclusion to other courts. It's itself a special law. So therefore, this maximum is not applicable when there is
No
a special
further
law.
argument is necessary on this case. Next point.
And our third point is, with respect to the 19, they correctly said that they invoked public order as a legal institution. But in that also it has to abide by the test of proportionality, which did not happen in this present case classification. They could have engaged intersection, but they chose jamming, which is the most restrictive measure that they chose. And
They said that you have violated principle of natural justice. When you obtained the expert report, they were not party to that. They have not have the right to say. They are not ready.
My lord, this is because we have just assessed the radiation level on an objective level grid. They can now also come before us and say that assess it in front of us. We will get the same results to it.
But the formula is technically data, right? It is preparing the promise. What step you have taken?
But I think the report that you mentioned is only with respect
Further, my lords, the last separation matter.
Germany has taken.
And that's the VLF terminals, they are falling in some other state. It is not the all data that AstroNet is transmitting is going to some other ones.
He was there. What step you have taken?
Now, the report has come before us. We will conduct our own investigations and find out if this veracity to the report is acceptable.
I was submitted this report.
That's a state report.
No, I was submitted the report.
Very good. Thank you.
How much? More meetings. Are you sure? One. 1 minute extra.
For an extension of a minute, I was asking you, but as possible, but I was going to summarize this up. On a lighter, on a lighter note, the councils on which to be created have not sought any prayer before this one. Not to their oral meetings, not to their written meetings. So the council is unsure what to do. Coming to the revertance stated by my
Think
friend.
you need lot of arguments. You should have only said that no prayer.
No relief. I feel
Indeed,
that means the
indeed. My learned friend during the revertance stated that the jammers were connectivity across the nation. But the council would like to clarify that the jammers were restricted to only 4 districts and also a sunset clause of 60. And if the union would have provided us a geofence skills, we would have stopped the jammers order. Second, with regards to the SCN, my learned friend again has misled this honorable bench by stating that the NGO's report was only attached to the case. But I would like to clarify that the state report, along with the petition signed by 1,500 tribal residents, was the cause of the SCN and it was duly attached to the case. That is all from the end of the defendants. Thank you. Much.
The session has now concluded. I request the members of the audience to kindly wait until our dignitaries proceed.
believe all phones and electronic gadgets are switched off. If not, please make sure you do. Good afternoon, everyone. A very warm welcome to all the dignitaries, faculties, and students present here. I am Sharon Rose, your host for the day. If you walked past these courtrooms over the last 3 days, you wouldn't just have heard arguments, you would have heard conviction. Not the kind that stays confined to textbooks, but the kind that is tested, pushed, and questioned to its limits and still holds. And that is exactly what Themis, the sixth Moot Court competition, has been. I remember a senior once telling me, there will come a moment in your argument where you realize it's no longer going the way you planned. And in that moment, you'll discover whether you were prepared or whether you just rehearsed. And today, as we come together for the valedictory ceremony, we're not just marking the end of an event. We're acknowledging a process, one that is challenged, shaped, and in many ways transformed everyone who was a part of it. It is my absolute privilege to welcome all those who've joined us this afternoon to be a part of this moment. We're truly honored to have with us someone whose contributions to the legal field has inspired generations of legal mind. His Lordship Honorable Justice Uday Umesh Lalit, the 49th Chief Justice of India, whose journey from a distinguished senior advocate to the Supreme Court and eventually to the office of the Chief Justice reflects a career marked by excellence, integrity, and deep contribution to Indian jurisprudence. Sir, it's an honor to have you and your wife, Ms. Amita Uday Lalit, here with us. We're also grateful to have with us Honorable Justice Ashim Kumar Roy, former judge of the High Court of Calcutta, State of West Bengal, and former Lokayukta; Dr. Jyotsna Yagnik, former principal judge, City Civil and Sessions Court, Ahmedabad, and former Pro Vice Chancellor at Damas University; Professor Dr. Subir Kumar Roy, Professor, Department of Law, and former officiating registrar, Bankura University, West Bengal; Father Justin P. Verghese, academic coordinator, Christ University, Pune, Lavasa; Dr. Anta Sebastian, head of the Department School of Law; and our faculty coordinators, Ms. Shubhi Thakur, Dr. Sarbhani Bhov Meghdeb, and Ms. Shaili Jain. I would also like to extend a warm welcome to all our respected faculty members and everyone in the audience. Before we move ahead, it is only right that we hear from the leadership that guides us. I now invite our academic coordinator, Father Justin P. Verghese, to address the gathering.
Former Chief Justice, His Lordship Uday Umesh Lalit and Mrs. Lalit, former Judge of the High Court of Calcutta and Loyakta of the State of West Bengal, Honorable Justice Ashim Kumar Roy, former Principal District Judge and former Pro Vice Chancellor of Damas University, Dr. Jyotsna, former officiating registrar of Bankura University, Professor Dr. Subir Kumar, head of the department, Dr. Anta Sebastian, and my dear participants and Christ family. Today, we are truly honored by the presence of our distinguished guest. Your presence carries a message in itself that the pursuit of justice and legal excellence is worth celebrating and worth passing forward to the next generation. On behalf of Christ University, we are deeply grateful that you chose to be with us today. And to every participant, 3 days ago, you arrived here as strangers. You came from different institutions, different cities, different corners of this country. Today you leave having challenged each other, having listened to each other, and having spent 3 intense days in each other's company. That is not a small thing. Something shifts in a person when they do that. These 3 days have given you something that goes beyond what any classroom can fully teach. You have learned to hold your ground with confidence while staying genuinely open to a better argument. Balance between conviction and humility. I believe the truest mark of not just of a good lawyer, but of a good human being is that. And it is not easy to find the same. At this juncture, I would like to tell each and every one of you, whether you are going home with a trophy or taking a certificate of participation with you, please do not reduce this experience to its result. The person sitting next to you in this hall today may be your colleague 10 years from now, your opposing counsel, or perhaps your closest friend in the profession. The legal world in India is far more connected than it first appears. Treat this relationship with care. At Christ, we believe that education is not simply about filling minds, but it is about transforming people. I hope that in some small way, these 3 days have done that for each and every one of you, the participants. Stay curious and do come back to us someday, maybe as our LLM students, for those who want to wish to proceed with your LLM studies, or maybe those who want to stay longer, complete your LLM, complete your PhD, come here as faculty members, or even as judges for the similar events, or as a guest, like how our honorable judges have come here today. I hope that you all will have a great future ahead. So wishing everyone all the very best and congratulating all the organizers, especially the faculty coordinators for the same, Dr. Sarbani ma'am, Shaili ma'am, and Shubhi ma'am, and all the student coordinators. I would like to just raise your hand. You can, wherever you are. The student coordinators and also all the people who organize. Can we have a big round of applause for all of them? It was not an overnight event. They have been meeting me for a long time for the preparation, and they made it happen, promoted the event, and the more number of national law colleges really shows how we maintained the quality over the last 5 years. So I would like to thank each and every participant who came over here. Can we have a round of applause for them too, traveling all the way from their respective places, reaching over here and putting up their best performance over here. Thank you so much. And all the judges, can we have another round of applause for all the judges at different levels? Few of them are not here, but still I would like to thank each and every one of them. And in any way, if I missed any names, all the logistics and all other teams who were working hard, and all the volunteers of this particular event, I would really love to appreciate and thank you for making it happen, and wish you all the very best. Thank you.
Thank you, Father. Your words truly set the tone for the rest of the day. As students of law, there are certain names we encounter long before we step into a courtroom. Through judgments, through legal discourse, to the very principles that shape the understanding of justice. These are names we read, analyze, and learn from. And every once in a while, we are given the rare privilege of witnessing such a presence in person. We're deeply honored to have with us His Lordship Honorable Justice Uday Umesh Lalit, the 49th Chief Justice of India, a distinguished jurist whose journey through the legal profession is nothing short of remarkable. From being enrolled as an advocate in 1983 to being designated as a senior advocate by the Supreme Court, to serving as amicus curiae in several significant matters, and even as special public prosecutor in one of the country's most high-profile cases, his career reflects depth, versatility, and unwavering commitment to law. What makes his journey even more exceptional is that he is among the very few in the history of our judiciary to be directly elevated from the bar to the Supreme Court, a testament to the immense trust placed in his legal acumen and integrity. Over the years, he has been a part of several landmark decisions that have shaped the course of Indian jurisprudence, including Shaira Bhanu versus Union of India, which marked a significant step in constitutional and personal law discourse, and Indian Broadcasting and Digital Foundation versus Telecom Regulatory Authority of India, reflecting his engagement with evolving regulatory frameworks in the media landscape. For many of us here, he's not just a name we've studied, but a standard we aspire to. To stand in the presence of someone whose work we've read, whose judgments we've discussed, and whose journey continues to inspire is truly a privilege. With great respect, we now proceed to felicitate our esteemed chief guest. May I request Academic Coordinator, Father Justin P. Verghese, and our head of the department, Dr. Anta Sebastian, to kindly join us on stage and felicitate Honorable Justice Lalit. May I also request Justice Ashim Kumar Roy onto the stage? I kindly request Dr. Jyotsna Yagnik to join us on stage. I also request Professor Dr. Subir Kumar Roy to join us on stage. Thank you for graciously accepting the felicitation. we now have the privilege of learning from your address. May I request Honorable Justice Lalit to kindly address the gathering?
Father Verghese, Academic Coordinator for this university, Dr. Sebastian, Head of the Department, Justice Hashim Kumar Roy, Dr. Jyotsna Yagnik, and Dr. Shubir Kumar Roy, the judges in the final round, all the other judges, the faculty members of this university, the participating students, and the students of the university, all those who have been in the organizing committees, all of you. It's a privilege to be here. Any moot court competition, perhaps I think you must have heard it number of times. What are the advantages of moot courts? What are the advantages of how moot court shapes up your career? How it helps you to chisel your faculties, sharpen your focus, everything. So all of it, I won't bother you with that, correct? You have heard it number of times. I have been given a specific task, and that is to say that why you should choose litigation as a career. I am here, perhaps, I think, acting as a counsel, trying to convince you that litigation appears to be one of the rosy pictures in front of you. So therefore, choose that. Well, traditionally, lawyers have always been in what is called litigation fold. When I became a lawyer, only few of us used to have a career, what is called corporate law. You know, when Madhav Menon started this movement of having national law schools, the idea behind that was that give the lawyers all that skill which the profession demands from him or her at every juncture. Have you noticed one thing, that a student who studies medicine, after he or she gets a degree, the next day he or she can open a clinic and start dispensing medicines. So therefore, the entire professional course which he or she undertakes enables that individual to come up to such levels as a professional, which would enable him or her to serve the community in its complete sort of, sense of the term. Same thing with engineers. The next day they are absorbed in occupations with almost every profession. But think of a lawyer. Will he or will she be able to argue the matters the next day onwards in a court of law? Perhaps I think that unfolds a different challenge altogether. And that is the reason why in my entire 3 years study of law, I had only one topic, which was moot court, which was only 3 or 4 periods in a year, that's all. So we never studied moots or mooting as a subject. That is precisely why Madhav Menon came with this idea that let us change the entire spectrum of education, legal education, and therefore started the principle that catch them young. So therefore, rather than allowing them to spend 3 years pursuing a graduate degree and then absorbing them in a law college, why not have a 5-year degree course? And that revolutionary idea has gained ground to such an extent that we now see the avalanche of all the law schools and the universities teaching 5-year law courses. But leave aside that, what is the advantage of being a litigator? A litigator, unlike, I don't mean disrespect to those who are in the corporate set, but a litigator is constantly who engages himself or herself in challenges day in and day out. And in order to meet those challenges in life, one has to be constantly up on toes. Number one, improve your knowledge as one goes by. Keep on adding to your repertoire and keep on improving as the stage goes by. I have spent something like, say, 43 years in this field of law. When the first year when I joined the bar, and today when I see myself, those last 43 years, there's a substantial difference. What is that difference? It is the journey that you undertake over the period of 43 years. Whatever my faculties which were there on the first day, they are not the same. What has happened? There has been some metamorphosis. What is that? It's constantly improving yourself, constantly trying to evolve yourself as a professional, as a student of law. Acquire knowledge, imbibe those good habits in you, and then keep proceeding further. Way back, Holmes had once said, what is study of law? Is it statute law, to study what the law is? And the second part is what the law ought to be. It is that distinctive section which is what the law ought to be, constantly keeps you going on. So you try to improve yourself. Every problem, every case with which you are confronted with will tell you what the law ought to be. And if you start answering those queries in your mind, start answering those questions, perhaps that if you do this, then you would be actually successful in life. What is the success? Is it the sort of achieving some office or achieving high kind of value in life? No, it is essentially the journey towards that. How you undertake your journey. How have you been? Have you been true, honest to your goals? Have you been true and honest to your whatever is supposed to be sort of undertaken by you at every juncture? Every case will unfold some problem or the other. Have you given your best of your ability for solving that as a problem? Have you been true to your brief? Have you been there is an integral part, and have you shown that integrity so far as the entire matter which has been entrusted to you by the person concerned? It is the sum and substance of that which tells you that whether your journey has been worth the while or not. Some of you have succeeded at every juncture. You have moved on to the next level of competition. Finally, only one person or one team succeeds. Does that mean that it is the only team which is supposed to be worthy enough? No, every person who has actually been part of the process, who has been part of that journey, who has been part of that competing element, has actually learned from the process. Do you know, in Australia, they had done a study, and what they found was that those who had been unsuccessful in life at some stage, that is to say, those who were not bestowed or favored with success in the initial stages of life, and yet they were able to gather themselves, to equip themselves with greater faculties, greater kind of, perseverance, were able to succeed finally at the destination. So, what does that mean? Success is essentially what? It's the sum total of your journey. Now, go back to your practice. What normally happens is, when it comes to corporate law or corporate jobs, you tend to become complacent when something is offered to you as a package. It's always a competitive package which you accept that may seep in an element of complacency and which may kill the initiative on your part or the ability to improve yourself at every juncture. The moment your belly is satiated, there is no hunger left. And that perhaps is the reason why, after many years in corporate structure, people start feeling the element of glass ceiling, or they feel that perhaps I think I am not rising so much in life as perhaps my other competitors who have chosen litigation as a field of activity. Whereas what happens in litigation is, in the initial stages, you may not get enough money. There's a very beautiful saying. Somebody came out with an equation that first 10 years of your life as a professional, you work for 10 units, get paid for 1. Next 10 years of your life, you work for 10, get paid for 10. Next 10 years of life, that is 21st to 30, you work for 1, get paid for 10. And what happens after 30 years? The sky is the limit. So therefore, as a professional, as somebody who is in litigation, initial stages may not be so convenient, may be quite competitive, may demand some kind of sacrifice from you, from your family, from those who are close to you. But as you start progressing further, the life becomes completely of a different dimension. And that is something which is possible if you are in the litigation front. I'm not suggesting that this is not possible in corporate world. It is also possible. The only thing is that corporate world kills your initiative. Whereas this encourages you to have that initiative. Do you know the first brief which Mr. Palkiwala had on the original side of Bombay High Court? He was the 7th person in the appearances list. That is to say, A plus B plus C plus D plus E plus F. That's how it went. And the 7th man in the lineup was Mr. Palkiwala. It was a long course suit. The very same suit continued for next almost 7-8 years. And from the 4th year onwards, Palkiwala was the first in the appearances list. And all those persons who were above him, 3rd, 4th, 5th, were now assisting him. That is possible in litigation. Because the moment you have that kind of ability, the moment you have that kind of capacity, then there is no limit. You know, what is this legal profession, how it distinguishes itself from the other profession? Have you ever given a thought to it? See, what the doctor does within the 4 walls of the operation theatre, nobody outside that theatre knows whether he has done an excellent job or has he really botched it up. People are completely unaware. What an architect does by way of drawings, whether he himself has done it or somebody assisting him has done it, people are completely unaware. But when a lawyer appears in court, it is his or her performance which is the only thing which matters in court. If he or she is good, then that itself acts as a demonstration effect. There are people who are sitting behind you, those 20 odd people coming from the profession or the spectators, who will be your greatest piece of advertisers. They will start telling people, oh, this youngster has a lot of promise. Oh, this youngster, she did extremely well. My wife at times, keeps telling me, why do you come and tell me that so-and-so youngster did exceedingly well today? Because this is how, as a judge, I used to appreciate that. This is how everybody in the court hall appreciates it. So the moment you have talent, it is the instant result and the instant reward which you get. Whereas in corporate setup, whatever you do, perhaps I think the outside world may not easily know about your conquests, about your ideas or acquisitions. And that is the reason why, because this becomes the most demonstration effect that those lawyers who are successful, they attain the heights at such accelerated speed that it's beyond comprehension that how is it that some people go to such levels in the profession. So this becomes possible only if you are in litigation. Of course, the advantages up till now were that very well those who are in litigation would normally be picked up to be in the judiciary. But now there are exceptions. Now one of the judges in Delhi High Court is somebody who was actually part of the corporate setup but has been picked up to be a judge. So therefore, the distinctions are blurring. But at the same time, the greatest advantage is to be in the litigation. If you happen to be in the litigation, the chances are that your talent will immediately get recognized, acknowledged, and rewarded. And that gives you tremendous fillip in life, because that's the encouragement at every juncture. Encouragement in the form of earning, encouragement in the form of greater kind of, workload, encourage in the form of challenging assignments. So these are something which will give you greatest job satisfaction if you are in litigation side. These are some of the advantages which I wanted to place before you. Now there is one more thing which I must actually tell you. What is it that distinguishes a lawyer? A lawyer must have the greatest what is called persuasive ability. So your research, etc., everything is correct. In every profession, whether it is engineering, medicine, you are struggling against the laws of nature. So once you understand the laws of nature, you have virtually mastered your trade or profession. Whoever is mechanical engineer, once he knows how the mechanics are supposed to work, he would have mastered the entire trade or profession. That doesn't happen in the profession as a lawyer. The reason is very simple. You're dealing with human problems. Number one, you have to convince the judge in front of you or the judges in front of you, who are, again, human beings. There is nothing definite what may weigh with one and what may not weigh with the other. So therefore, every judge comes with a typical kind of, mindset, which you as a lawyer must be able to fathom, which you as a lawyer must be able to understand, and then navigate your matter accordingly. This is not just one dimension. The other dimension is your opponent. he may create an impression which may be adverse to you so far as the judge is concerned. So therefore, you have to be constantly aware of the second dimension which he is able to imprint on the mind of the judge. And the third dimension is that between two lawyers, you must now understand what is the capacity of your opponent and try to find solutions to get over that difficulty. So therefore, the profession of a lawyer is three-dimensional idea. Is not just a unidimensional that you are grappling with laws of nature. And those who are good at understanding this three-dimensional problem are the most successful lawyers anywhere in the world. So therefore, as young practitioners, as young lawyers, which you will turn out in next about a year or two, understand this, appreciate this, and then sky is the limit for you. Thank you so much.
Thank you, sir, for those insightful words. We're truly grateful for your presence with us today and for sharing your thoughts with us. To take us through a brief reflection of the past 3 days, I invite Srija and Ujjwal. Respected dignitaries, esteemed members of the judiciary, distinguished guests, faculty members, participants, and my dear fellow Christites. Good morning. It is a matter of immense pride for us today to present the report for the 6th edition of Themis Moot Court Competition 2026. Conducted from 27th March to 29th March 2026, Themis brought teams from across the country from more than 25 states, competing on a proposition entered around constitutional law, federalism, and data governance. With a prize pool of 3 lakh rupees, the competition is supported by Dexon Global LLP, featured recognitions including the Best Speaker Award, sponsored by ALMT Legal Mumbai. This competition has commenced on 27th March 2026 with an engaging SEC online session for our researchers, equipping them with researcher tools for the researcher's test. The memorial exchange and the draw of lots ensure transparency, while judges' briefing helped maintain a uniform standard of evaluation. The memorial exchange and draw of lots additionally fostered the next set of the competition, which is the preliminary round 1. We witnessed 15 courtrooms functioning simultaneously with 30 judges and 30 teams, creating an atmosphere that truly mirrored the scale of this competition. Across both preliminary rounds, participants engaged in hours of continuous arguments. Teams created a healthy competition, and there was a remarkable experience for all the teams present here. The competition then advanced to the evening session, which is the preliminary round 2, where the level of the discourse has become more nuanced and competitive. This day has concluded with the announcement of results and the top 8 teams qualifying for the final rounds on day 2. As the student organizers, on the day 1, we just did not witness the beginning of the competition, but the culmination of the 3 months of the hard work that it took to organize this event. From coordinating courtrooms and judges to ensuring every round ran seamlessly was incredibly proud. Seeing it all come together was truly rewarding. Now, Ujjwal will take us through the second phase of this competition for day 2, day 3, and the valedictory ceremony.
Day 2, 28th March 2026, marked the commencement of the quarterfinals rounds. The quarterfinals saw a sharp rise in the level of competition, with teams presenting more refined arguments and strategic rebuttals. This was followed by semi-final rounds, which were adjudicated by the esteemed panel. Mr. Mohammad Zafar Imam, Principal Judge, Bombay District Court, and former presiding officer and Debts Recovery Tribunal. Captain Pankaj, Director at Quadrant Legal. Their insightful questions and observations elevated the quality of the rounds and challenged participants to think beyond the written law. By the end of the day, 2 outstanding teams emerged, securing their place in the final round. Day 3, 29th March 2026, marked the culmination of distinguished bench comprising Honorable Justice Ashim Kumar Roy, former judge of the Calcutta High Court, former Lokayukta for the state of West Bengal. Professor Dr. Jyotsna Yagnik, former Principal Judge, City Civil and Sessions Court, Ahmedabad, former Pro Vice Chancellor, Adamas University. Professor Dr. Subir Kumar Roy, Professor, Department of Law, Bankura University, and former officiating registrar of Bankura University. The finalists displayed exceptional advocacy, engaging with complex constitutional issues with clarity, confidence, and depth. Following the final round, we gathered here for the valedictory ceremony, the most awaited moment for Themis. The ceremony was not merely a conclusion, but a celebration of excellence, perseverance, and spirit of mooting. Awards are presented for winners team, runners up team, best speaker, which is sponsored by ALMT Legal Mumbai, best researcher, best memorial. The valedictory is also a testament of gratitude, acknowledging the support of our judges, sponsors, faculty members, and the organizing committee, whose efforts ensured the seamless execution of this large-scale event. For us, as the student conveners, Themis has more been than just an event. It has been an experience of leadership, responsibility, and collaboration. From handling logistics to witnessing some of the finest advocacy, this journey has been both demanding and incredibly fulfilling. With this, we proudly conclude the report of the 6th Themis Moot Court Competition 2026. Thank you.
Thank you, Ujjwal and Srija. It's always interesting to look back at moments like these. They tend to mean a little more in hindsight. And now, before we move ahead, we take a moment to revisit Themis. What you're about to see is a small surprise from the Moot Court Society, a glimpse into their journey. Let's take a look at the Themis after.
Honorable Justice, His Lordship UU Lalit, Mrs. Lalit, Justice Ashim Kumar Roy, former Justice, Calcutta High Court, and former Logayukt, Father Justin, the academic coordinator, Dr. Jyotsna, former District Court Judge, and the Pro Vice Chancellor, Adamas University, and Dr. Subir Kumar Roy, and dear faculty coordinators, faculties, participants, and Christates. Just during this video, I got a paper. It's given by convener, and it is written, results do not open. And after that, there is a small line, participants are behind. So far I didn't open it, so I am opening it. Shall we start? So we will start with the best memorial or best speaker. Best memorial. Okay. Best memorial. Okay, the best memorial goes to TCU 17. To give the trophy and certificates, I cordially invite Dr. Sudeep Roy to the stage. The Best Researcher Award goes to Lakshmi and Jitesh, TCU 03. And to give the award, I cordially invite Dr. Jolsina to the stage. The Best Speaker Award goes to, any guess? Rahul Mishra. TCU 26. And I invite Justice Ashim Kumar Roy to the stage to give the award. Sir, please be on the stage. Sir, please be on the stage. And now, I invite all the dignitaries to the stage. The final and the winner. Any guess? You witnessed it. Can't hear. How many of you vote for 04? Anyway, judges have already done it. So your vote doesn't matter. The winners are TCU 04. So I humbly request Justice UU Lilith to hand over the trophy to the winners. TCU 4 is from National University, Jodhpur. And along with this trophy, they will be getting a cash prize of 1 lakh rupees. Now everybody knows who is the runners up. So TCU 10. And they represent Nirma University. And the runners up is going to be given a cash prize of 70,000. Yeah, go. Thank you.
Congratulations to all the winners and to everyone who participated. The level of competition over the past few days has been truly commendable, and each one of you has contributed to making this moat what it was. No event like this comes together without the efforts of many people behind the scenes. And to formally express our gratitude, I invite Ms. Shubhi Thakur to deliver the word of thanks.
Good afternoon, everybody. As we bring this unforgettable 6th Themis Moot Court Competition 2026 to a close, I, Shubhi Thakur, stand here on behalf of the entire Moot Court Society with a heart full of gratitude and pride. First and foremost, our deepest and most sincere gratitude to our Chief Guest, His Lordship, Justice Uday Umesh Lalit, former Chief Justice of India. Sir, your presence today means more than what words can express. For students of law, to be in the presence of someone who has contributed so profoundly to the Indian jurisprudence is not just an honor, it's a moment of inspiration that stays for life. Thank you for taking time to be here and for encouraging all my students and for reminding us why we chose this profession. We're equally grateful for the presence of Honorable Justice Shri Ashim Kumar Roy, former judge of the High Court of Calcutta and former Lokayukta for West Bengal. Professor Dr. Jyotsna Yagnik, former Principal Judge, City Civil and Sessions Court, Ahmedabad, and former Pro-Vice Chancellor, Adamas University. Professor Dr. Subir Kumar Roy, Professor, Department of Law, and former Officiating Registrar, Bankura University, West Bengal. A special thanks also to Mrs. Amita Umesh Lalit for being with us today. I extend my sincere thanks to Father Dr. Leja Thomas, our Dean and Director. His vision and leadership lit the path for this event. To Father Justin P. Verghese, our academic coordinator, thank you for your unwavering support throughout the event. To our associate dean, Dr. K. Parmeswaran, thank you for your constant encouragement and belief in us. A heartfelt thank you to Dr. Anta Sebastian, head of the Department School of Law. Sir, your guidance, your faith, your steadfast support has been our anchor. You believe in us, and we're truly grateful for everything that you've done for us. At very core of this entire journey were my fellow coordinators, Dr. Sarbini Bhomikdev and Ms. Shelly Jain. This Moot did not just test the participant, it tested us. It tested our patience, our resilience, and our ability to hold things together when nothing seems to go as planned. And through it all, we stood together as a team. I could not have asked for better people to stand beside me today. Thank you for being my strength. Every faculty member who supported us deserves a heartfelt appreciation. A special mention to Shaheen sir, whose encouragement and support meant a lot to the team. Thank you, Chetan sir, for setting example that me and my team kept revisiting. To the academic office, especially Reshma ma'am, thank you for always being there, for being somebody that my students can run to and rely on. From classroom arrangements to administrative help to everything, thank you so much, ma'am. A quiet but powerful force behind this event was our administrative and support staff, BG ma'am, Ali sir, Datta sir, Javed sir, and Sandeep sir. You made sure everything worked even when it seemed impossible. Your impeccable coordination ensured everything ran like a clockwork. You are the unsung heroes of this entire competition, and we are ever so truly grateful. Santosh sir and the entire library department, Shivanand sir, Apu sir, the entire IT department, the accounts department, hostel department, security team, Lavasa security, housekeeping staff, NCC, SWO, every single one of you played a crucial role in this event. A special mention to Dexon Global for drafting the Moot proposition and evaluating our memorials. We also thank ALMT Legal for sponsoring the Best Speaker Award and SCC for their encouraging session and support. Our judges, more than 40 of them from all across India, they gave us their time, their expertise, their patience, and this competition stands as a strength of your commitment. To everyone who came to witness this finals, thank you so much for being here today. And thank you so much for supporting all our participants and all of us. And now, the heart of Themis, our student community, our conveners, Ms. Shrija Velanki and Mr. Ujjwal Ahuja. They are the leaders. And there are leaders, and then there are people who quietly carry the entire event on their shoulders without even making it about themselves, and you both were exactly that. The number of things you handled, the calm you maintained, the way you built this team, and the way you held them together, it did not go unnoticed. This event stands as it is because of the two of you. Kashi and Vidhi, their entire team, who ensured every participant felt welcomed and taken care of. You gave Themis its warmth. Karthik, Ritikesh, Paritosh, our logistics team, they were the problem solvers, they were the runners, the fixers, and sometimes the magician behind all of this that was happening. Within 30 minutes, this entire setup was taken back to Moot Court Hall and everything was arranged as it is. Impeccable work, you guys. A special mention to Ayush Paul. This person was the calm of the event. I have no words. I have no words to express my appreciation for him. I just had to call him and the answer would always be, yes ma'am, and he would just get it done somehow. I don't know how. Yashvi and Devshri, the floor managers, you brought order to chaos with such ease. I am so ever so grateful and thankful to both of you. Prachi, our court clerk's head. You built an entire team from scratch. Where is Prachi? Yes, you built an entire team from the scratch. Most of our Moot Court clerks were the first year students, and for them, this was the first time they were seeing a Moot Court competition. Yet they performed with confidence because you believed in them. Rishika, leading the judges usher along with Tanu, Bhavish, Kea, Parvati, and the entire team. You handled the entire coordination so seamlessly. I'm so ever so grateful and thankful to all of you. Aniket and Akansha, the documentation and scoring, our scoring team. You handled it with the most critical precision. My jack of all trades, Arunam, Sean, and Jitin. I don't know which head to put them under, but they were there. They were just everywhere. So they were just everywhere, and I don't know which head to put them under. But yes, I'm very grateful for all your support. Indrajit, Shashwat, Milan, the entire media team, thank you. Thank you for capturing all those moments that will become the memories that we revisit forever. Thank you, CDL, also for covering the valedictory and the entire event as well. A special thanks to our MCs, Sharon for valedictory and Anya for the inauguration. Mithali, Spriha, Priyanka, the entire food coordination team, thank you so much for your constant effort to ensure that no one was left uncared for, which is no small feat. Thank you so much. Every court clerk, every judge usher, every volunteer, each one of you mattered. Each one of you contributed to something that is so very bigger than yourself. My entire student team of over 70 students. You were not just a team, you were a family through this journey. You were my strength, you were everything. You were the calm in the moments of panic, my laughter, my chaos, and sometimes also the reason for that chaos also. And most importantly, you were the reason why this entire event came together. This was your event, this was your legacy, this is what you have created. And if my team or I have let you down in any way, I take full responsibility of it, and I offer my sincerest apologies for it. As we say in the courtroom, the counsel seeks ignorance, but please know that it was never our intention. We gave our all just as all of you did. And finally, to our participants who've traveled from across the country, thank you for trusting us, for competing with such passion, dedication, for making this competition so very meaningful. Before I conclude, there's one last person I want to thank. Thank you, Papa, for coming all the way from Raipur, for being here. He never saw me as a mooter, but I'm sure today he saw some of the finest mooters in the country. As we close today, lastly, congratulations to all the winners. Your hard work, your perseverance, your advocacy have truly stood out. Thank you so much for being here. Your achievement is very well deserved. As we close today, we do not just conclude an event. We carry forward friendships, like Ujjwal said. We carry forward friendships, lessons, and memories that will stay with us long after this entire stage is empty. Themis 26 was not just organized. It was built together with the entire community that is sitting here, and I am so grateful and thankful to each and every one of you present over here. Thank you for being a part of it. Thank you so much.
Thank you, ma'am, for ending the ceremony on such a meaningful note. With that, we come to the close of Themis, the 6th Moot Court competition. What remains isn't just the outcome, but the discipline of thinking, questioning, and standing by an idea under pressure. We hope your time here in Lavasa has been both rewarding and worthwhile. I now request everyone to kindly rise